Oh, no problem, and I know Ron just told the jury that we were dealing with some technical issues, and I'm sure they were fine. Okay, anything else before I bring out the panel?
Yes, Your Honor, we had another issue we wanted to raise before we get started. With regard to the court's canvass of Mr. Jones, there were some in limine rulings that the court did not cover.
That is true.
And so we wanted to make sure that the court was aware of that.
I am. Did you speak with Attorney Pattis to see if there's anything that should be added by agreement?
I did speak with Attorney Pattis about the issues that the court had omitted from our perspective. I leave it to Attorney Pattis again as the court.
Do you want to just tell me what the issues are?
So the issues that were omitted are the PQPR is a separate entity from free speech systems.
Well, that question won't be asked, so I thought that was such a minor thing.
Your Honor, it's certainly not our intent to ask those questions.
So I would just say that if there's a non-responsive answer that makes that statement, I'll just instruct the jury accordingly.
Your Honor, okay.
All right, Attorney Pattis, does that make sense to you, or would you prefer that I canvass Mr. Jones? Up to you. It's your call.
I leave it to the court's discretion. My view is if we're going to do part, we should do the whole, and having done part, we should do the whole.
Okay, so Mr. Jones, I've entered a ruling that there can be, you're not going.
I'm so sorry to interrupt the court. Before we do that, there are some other issues. So may I give the court my list?
I was just going to do one by one so I don't forget. So, Mr. Jones, there was a ruling that I entered that there can be no evidence, and so you won't be questioned along the lines of PQPR and free speech systems being separate entities. So you can't say that, essentially. You're not going to be asked it. Okay, next issue.
The next issue is no evidence or argument that Mr. Jones did not profit from Sandy Hook coverage.
Okay, so sir, I made that ruling as well. No one is going to ask you that question, so you can't just out of the blue say, well, I didn't profit. Again, I understand you may not agree with that ruling, but that is the ruling for at least at this trial level. Do you understand, sir? Yes, sir. Next.
And the last issue is that there should be no evidence or argument that Mr. Jones, it would be unfair to hold him accountable in damages in this case because of his deplatforming, because of the Texas verdict, or because of his bankruptcy.
All right, well, that wasn't a ruling that I entered, so if any of the questions are asked, I assume that would just be objected to, and if the
Your Honor, we believe that as the law of the case has developed, that has been a ruling of the court, and also that was actually part of the motion in limine ruling. That's been our understanding.
Right. Let me ask you, Attorney Pattis, do you see any questions that are going to be asked that would elicit an answer about bankruptcy?
Hard to know. I mean, obviously,
I didn't hear you. I'm sorry.
I'm not asking for a proffer on the scope of the cross, so it's hard to know. My view is, well, you know my view of the case. We've argued it for days here. It's possible that could happen. I don't know how Mr. Jones will construe the questions that Attorney Maddie has. We're not attempting to salt the record here. So if the court has concerns or my adversary has concerns, I'll leave it to the court's discretion.
Right. I'm just trying to figure out a scenario why bankruptcy should come up in this court. Can either of you think of a scenario?
No. I don't know what the questions they are
All right.
that they're going to ask. So,
Well, and both sides this applies to, if there is an issue, the objection is just going to be motion to eliminate. I can't think of a possible reason that the bankruptcy should come out, be improper. So I would say, Mr. Jones, that you're not to testify with respect to your bankruptcy proceedings, and you're not going to be asked. Okay, sir? I understand you don't agree with it, but that is just the court's order.
I understand.
Okay, very well.
Your Honor, the Texas verdict is another concern, and the last is the deplatforming.
About
No.
that, I can't see any reason that that would be admissible evidence in this court, so I would not allow that question. And Mr. Jones, that's not something that you're going to be able to talk about because it would not be proper in this case at this level, okay?
Yeah.
And then the deplatforming, Attorney Pattis, did you want to address the deplatforming issue? This is a hearing in damages.
No.
Okay, so the deplatforming issue is not an issue, sir, for this jury to address, all right? So again, no one's going to ask you. If the question's asked, you'll hear an objection, motion, and limine ruling or something like that. You're not to mention the deplatforming. All right, so I would appreciate it if there is any concern that a question is going to elicit any of the testimony that I've just addressed with Mr. Jones, that we follow what Attorney Pattis says and just, say something along the lines of objection, motion, and limine. All right, and sir, and I assume there will be because there have been objections throughout the trial so far, but I'm sure your attorney has told you if someone makes such an objection, just don't answer and let me deal with it. Okay? All right, can we get our jury now? They got here early, so I'd like to get started.
Please, Judge.
Okay. And while we're waiting to bring out the panel, as I try to remember to say every day, in accordance with judicial branch policy, only the specific individuals or entities who are authorized to record or photograph or video may do so. Anyone who does so without permission will have their device or devices confiscated and will be removed from the courtroom. So please make sure we abide by that rule. And also, if you haven't already done so, turn off your Apple Watches and phones, or at least put them to vibrate. I've done that myself. It's a rainy day today. I think it's our first day of bad weather. Welcome back, everyone. Good morning. Good morning. Ron's handing out your notebooks. Please be seated, make yourselves comfortable. Counsel stipulate that the entire panel has returned.
Yes, Your Honor.
I do.
All right, and Ron, I asked, and there were no notes with any jury conduct issues. And I'll just try to remind you every day, if and when something comes up, please make sure you follow that procedure. I want to thank you for your patience this morning. I know you were actually all here early, but we had some technical equipment issues that we had to deal with. But I guess it was a good day that you got your coffee machine in there. So I thought that might come in handy. You're very welcome. All right, Attorney Maddie, whenever you're ready, please.
Thank you, Your Honor. And good morning. The plaintiff is called Alex Jones.
Very well. Mr. Jones? Just watch the chords in your step when you come up. Remain standing.
Please raise your right hand. You solemnly swear or sincerely affirm that the evidence you shall give concerning this case shall be seated. Then I just need you to state your name, slowly spelling your last name for the record and the town in which you live.
Starting with my last name?
No, just state your name and spell your last name for
Okay.
the record.
Alexander E. Jones, Jones.
And your town?
Oh, Austin, Texas.
So there's word in the picture.
Oh, great, thank you.
If you want a bottle or
Thank you.
just let Mr. Jones get situated.
Thanks.
All right, you may inquire.
Thank you, Your Honor. Mr. Jones, you're here pursuant to a subpoena today, is that correct?
Yes.
You were deposed in Connecticut earlier this year, and at that time, I arranged to have a subpoena served on you to assure that you would appear at this trial, correct?
I believe so.
And you could have come to this courtroom at any time since we started if you wanted to, correct?
Yes.
Right. In fact, you know where the courthouse is because you've given press conferences right outside this courthouse yesterday and the day before, correct?
Yes.
But this is the first time you've been in the courtroom. Yes?
Yes.
This is the first time you've been under oath in this
Yes.
case, right? Against you about 4 years ago
Yes.
to seek justice from this jury for what you did to them, correct? You understand that's why we're here?
I understand they sued me, yes.
Right. And this is an important case. You understand that?
I mean, that's an opinion.
Okay. You don't think this is an important case? That's a yes or no, sir.
It's not, I don't really think it is a case. I don't think it is a case.
Okay. We're going to there's going to be a lot of this today. And
Objection, Judge.
All right, so let's iron out the wrinkles now. If you can answer the question with a yes or no, Mr. Jones, answer it with a yes or no. If you don't know the answer, you can say you don't know the answer. And of course, if there's an objection, you'll just wait for me to run the objection.
this is an important case, isn't it, Mr. Jones?
I think this is historic.
Okay. Mr. Jones, the judge just gave you an instruction.
Objection.
To answer the question, yes or
Objection,
no.
you turn to court.
So I'll
Should we do it again?
do this. So the question, Mr. Jones, is it an important case? And the answers that you can give are yes, no, or I don't know.
Yes.
You can understand why it would be very important to the families. Because you've been using this case as a marketing opportunity over the past couple of weeks, haven't you?
No.
Mr. Jones, you created a new website on Infowars.com called Kangaroo Court, just so your followers can watch this case, haven't you?
That's not a website.
What would you call a web page on Infowars.com?
It's a page.
Okay, page. Thank you for that correction. There's a web page on Infowars.com that you've titled Kangaroo Court, so that your followers can watch what's happening here, right?
Yes, that's my opinion.
Okay. And why don't we pull up, actually, Exhibit 504. This is, just for the witness, please. Exhibit 504. There's a screen down there for you, Mr. Jones. You see that?
Yes.
Okay, is that the Kangaroo Court page that you've had up and running?
Yes.
Okay, I'd offer it, Your Honor.
No objection.
All right.
And you see here, you've been clipping testimony that's been happening in this courtroom over the last couple of weeks, haven't you?
I have not been clipping, no.
You don't do that yourself. You have your employees do that.
I'm not even directing. No, I've not been there, and I don't direct most of the headlines.
They just know that this is what you want, right?
Objection calls for speculation.
Overruled.
I'm not supposed to talk about the prior rulings.
Excuse me, sir.
So how do I answer why I think something's a kangaroo court if I'm not supposed to say why I think it is?
The question that I just asked you, sir, was whether you knew that your employees wanted to do this, whether they knew that you wanted them to do
You
this.
do my objection on speculation.
And it's the same ruling. Do you understand that question, sir, or do you want it played back or repeated? Because I want to make sure you're answering the question that's
I don't know. I mean, I'm sure they agree with me. That's why they put that headline up.
And right above there, as you're saying, watch highlights from the Alex Jones Sandy Hook Kangaroo Court hearings, you're running an ad for Brain Force Plus, right?
Yes.
Orders a day, right? This is what you're showing your audience. The next generation of advanced neural activation and nootropics. Is that right?
Yes.
Okay. And how much is that going for on InfoWarsStore.com right now with the sale?
I don't know.
And ever since this trial started, and you've been calling it a kangaroo court yourself, right?
Yes.
You actually use that word a lot with your audience. You call people tyrants, don't you?
Only when they act like it.
Okay. And one way that you've been conveying to your audience that Judge Bellis has been acting like a tyrant is by showing her with lasers coming out of her eyes, right? You know you did that?
I didn't direct that. First time I saw it was in court.
Oh, so you've been watching this?
Yeah, I've been watching.
Okay. You could have just watched from the stage.
Objection, argumentative.
Sustained.
But you've been broadcasting your show during this trial, haven't you?
I have taped some of my show.
Let's pull up 477.
Is this full?
This should be in already.
It is a full exhibit.
And what was it, Ron, 477?
477, Your Honor.
This is the tyrant you've been telling your audience about, right? Yep.
I'm barred from saying why I said it, so
I didn't
can't-
ask you why.
Oh,
This is the tyrant you've been telling your audience about, right?
I believe.
Sir?
So, Mr. Jones,
Yes.
look at me. Yes, no, or I don't know.
I don't know
The answer is you don't know.
about that. I didn't make that.
This is the tyrant.
About the image or about me believing this is tyrannical? Can
No.
you restate the question, please?
Sure. I'll restate it for the third time for you.
Objection to the comments, move to strike.
This is,
Can we have one motion? Okay, thank you.
this picture right here, that's Judge Bellis, correct?
Yes.
Lasers coming out of her eyes, correct?
Yes.
That's who you've been referring to as a tyrant to your audience, correct?
Yes.
Okay, and you refer to tyrants to your audience a lot, right?
Some.
Right. Tyrants are people who are going to oppress others and strip them of their freedoms, correct?
That's a common definition.
Right. And you've not just called Judge Bellis a tyrant, but you said that this whole thing, what's happening here, is part of a plot, isn't it?
Objection, motion in limine.
No, not the whole thing. I think the jury's
Motion in
real.
limine.
So, just, can I have that question again?
Yeah, I think what I asked,
Don't
Judge,
answer it. Go ahead.
Understand.
Thank you.
what you've been telling your audience is that this whole thing is part of a plot, I believe is what I asked.
Objection, motion in limine. Politics.
That's a yes or no.
It's a yes, no, or I don't know, sir.
I
So,
thought there was, well,
He's going to talk about if this goes on, Hillary, this, that, and everything else. And I thought that politics, was out of it. He thinks this is a plot orchestrated by. Excuse me. I don't mean that. He thinks this trial reflects the effort of tyrants to silence him, including George Soros, Hillary Clinton, and others. And by asking this question, the door is being opened. I said it's part of the plot. Yeah, that opens the door.
And it hasn't just been, can we pull that back up?
I didn't hear the question.
I haven't asked one yet. It hasn't just been this way that you've been depicting the tyrant. Let me show you Exhibit 477. Is this 477? One moment. You also have displayed Judge Bellis engulfed in flames, haven't you, to your audience?
No. One of my crew made that. They make thousands of images.
Thousands of images.
just
sir.
1 second. Is this a full
exhibit?
No, it's not, Your Honor.
Pull it down, pull it down, pull it down. I'd offer it. You
No
just-
objection, Judge, I forgot the number.
461.
469?
1.
Thank you.
Do we have a bench copy?
Not at the moment, Your Honor. And that's Judge Bellis on the right there, isn't it?
Yes.
Engulfed in flames. And
that's it.
I didn't ask you the other person.
Oh, that's okay.
Yeah, that's another judge, right?
Objection, motion in limine.
That's not what I was going to say.
Objection, motion in
That's
limine.
another
There's no
producer's
question.
report. That's
So, Mr. Jones, because your attorney stood up and objected, so remember when there's.
I'll withdraw. I'll withdraw.
Okay.
but you,
Just-
Yeah,
just
another
one
person
second,
made this
one
report.
second. Just remember that when there's an objection, just,
be quiet.
yeah, that's good. Thank you.
Yes, thank you.
Another, one of your employees made that, right? Greg Reese?
Yes, it's another producer, who's an independent producer. Case, but yes, I think it's showing that Lady Liberty's being burned up by due process being erased.
And Mr. Jones, Greg Reese, are you saying he's not an employee of yours?
He's I believe he's a contractor now.
Okay, you pay him, yes?
Yes,
Okay, you pay him to create these video segments, right?
I mean,
Greg Reese reports,
he independently makes what he wants.
and you pay him for it.
Yes,
All right, and you paid him, you can take that down, you paid him to create a little mini documentary about Bill Aldenberg just this past week, didn't you?
I don't know who Bill Aldenberg is. Oh, he's the FBI guy, I remember now.
Yeah, so you paid him to make a little mini documentary featuring Bill Aldenberg, didn't you?
I think I saw a thumbnail for it. I don't believe I've watched it.
Mr. Jones, you aired it on your show, haven't you?
I have a filling crew. I've been here.
No, Mr. Jones. This was last week. You were in Austin last
Well,
week.
I don't watch the breaks, so
Okay, so what happens is when you're on your show, you go to break and they just show some video, and you have no knowledge of it. Is that what you're saying?
I mean, I watch a lot of it, but no, I go eat food. I go to the bathroom. I hadn't seen. I remember now seeing an article about it or something about it.
Well, this is take a look at Exhibit 513, Mr. Jones. Just pull it for Mr. Jones. You have it? You have it, Mr. Jones, right in front of you?
Oh,
That's it, right? That's a still shot from Greg Reese reports
yes,
featuring Bill Aldenberg.
I haven't. I don't remember this report, but I remember this fella. Don't know who he is. Never said his name until I saw him up here talking about me. And then I have seen this report posted. I haven't watched it.
Mr. Jones, you don't know if you ever said his name.
I'm sorry.
I've never said his name till now.
Know that?
Oh, okay. Show us.
Let's pull up Exhibit 50 before we get to that.
I mean, you mean recently?
There's no question, sir.
Wait for the question.
Yeah.
Exhibit 50, is that full or right?
It should be.
That is a full exhibit, Your
Thank
Honor.
you.
It is.
Mr. Jones, this has been introduced as a chart of all of the days for which you didn't produce any videos to us in which you talked about Sandy Hook. So let's start with April 8th, 2013. Did you say Bill Aldenberg's name on that day?
I don't believe so. I don't remember him. I don't believe so.
You don't know, do you?
I think I've said like two people's names.
You don't know whether you said Bill Aldenberg's name, do you?
From my memory, I'd never seen him before until he sued me.
Is it your sworn testimony to this jury that you never said Bill Aldenberg's name on any of these days here? Do you know that?
I got a pretty good memory, and the first I heard of him from my memory was when he sued me. I mean, but this was over 10 years. I mean, that's my recollection. I have never heard about him. I'm like, who's this FBI guy out of the list?
So
Yeah.
let's just make it clear then. You said 10 years ago. We got October 4th, 2021. So I just want to know.
Oh, I may have talked about him
I just
recently.
want to know. I just want to know.
Yeah.
Because you're here under oath. This is our chance.
Objection, Judge.
So I want-
Strike the commentary.
I want to know whether you can tell this jury under oath that you never said Bill Aldenberg's name. Yes or no?
Not until recently. I don't believe I ever said his name.
Yes or no?
Objection, he has answered.
I mean, I think I just said his name. I think I've said his name recently. I can't remember.
Okay. What about before? Can you tell this jury?
I don't believe I ever did.
So you don't know, do you?
If you've got me saying it, please show me. Refresh my
I'm
memory.
asking you.
No, it was news to me when he sued me. I didn't know who he
All right,
was.
Mr. Jones. Well, let's pull up 513.
I don't know whether the writings are going to run afoul. May I speak to Attorney Manny?
Absolutely.
Do you have any further?
I need to review the writings in lieu of the court's prior rulings, Judge.
Give me a moment.
Take your time.
Can we scroll down on it, please? Is there more than what's displayed on the screen?
Can you scroll down for Attorney Harris?
That's it.
If that's it, if all is on the screen, no objection. If there's no text accompanying it.
We'll offer it.
All right. Full exhibit.
So this is your webpage, band.video, right?
Yes.
You ran this video last week. You see here, Alex Jones, Kangaroo Court, watch day one, right?
My crew posted this.
Yeah. Mr. Jones, you own 100% of
Yes.
Future Systems, right? Okay, you're in charge, right?
I mean, yes. I'm just asking if I posted it. I didn't post it physically. I didn't make it.
Let's pull out of that. And the title of the video is FBI sues Alex Jones to destroy First Amendment. That's the title, right?
I mean, I think that's a point of view.
Excuse
I
me.
actually agree with that.
Mr. Jones. Oh, you agree? The FBI is a plaintiff in this case that sued you here. That's what you want to tell this jury?
I mean, he's an FBI agent and he's up here in his capacity. And when he got asked,
Excuse me, Mr. Jones. I asked you whether it's your testimony that the FBI is the plaintiff in this case. Is that your testimony?
I mean, I think this is a deep state situation. Yeah.
Okay. Mr. Jones, you understand what I'm asking you.
Objection, move to strike the commentary and
Right,
badger.
so how about if we just get an answer to the question?
Uh,
No, Mr. Jones, look over here. The question is the FBI a plaintiff in this case? Yes, no, or I don't know?
I mean, I don't think officially they are.
But this is what you tell your audience here, right? Did you see any Bill Aldenberg's testimony?
Objection,
I did.
You did.
This is what you tell your audience. Did you see the testimony?
Sustained, so can we break the question down?
But that's what you told your audience.
Which one, Judge?
That the FBI had sued you, right?
No, that's the headline that another person made. But
And this video right here, I don't know if you can see it, just as of September 15th, had 190,000 views, didn't it?
I watched quite a bit.
You heard him describe the threats he had received?
Yes.
You heard him describe the harassment he had received?
Yes.
You heard him describe years of feeling insecure as a result of the army that you sicked on?
Objection, Judge, move to strike that.
Sustained.
And
I mean, he said I never even said his name.
And then-
then,
No, yes.
disregard that.
So, Mr. Jones, your attorney objected.
Sorry.
No, let me finish. Okay. I sustained his objection and you answered it anyway. He won and you kept going. So just, why don't you take a break, drink a little water.
Okay.
Take a breath. And just remember, when Attorney Pattis objects, just, I think your words were that you would be quiet.
Thank
And
you.
then I'll rule.
You're right.
He won.
I'll slow down.
Okay. How's that, Attorney Pattis?
And then the jury is to formally disregard the comments of counsel.
So ordered.
And after all that, you still chose to put Bill Aldenberg's face up in front of
Objection.
your audience of
Assumes the fact,
hundreds
not
of
an
millions, correct?
Assumes that fact, not an evidence.
Overruled.
No, I did not direct Greg Reese to make this, but I think it's a good report.
Okay. So when you did become aware of it, you didn't take it down, did you?
No, I stand by the report,
Very good.
even though I'm watching.
So after Bill Aldenberg and after Judge Bellis, who's next, Mr. Jones?
Objection.
Sustained.
I mean, I guess if somebody's on national TV, I'm sorry.
Again, no, Mr. Thomas. Again, you're aware and you still answered.
Okay, I'm not hearing him.
Can you be louder? I never thought I would say this, Attorney Pattis.
Yes, Judge, I can be louder. How's that?
A little secret is I have serious hearing damage.
Okay, so.
I need to get a hearing aid soon, so.
So your client cannot hear, so.
Sorry, seriously, I can't hear you anymore.
So let's pull up just for the witness Exhibit 512.
One more time?
512. Take a look at the screen next to you. That's the landing page for band.video, your video page, right?
Yes.
I'll offer your honor.
May I have one moment, Judge?
Take your time.
So if anybody goes to your band.video page right now, first thing they can do is buy high quality storable food from you because it's back in stock, yes?
Yes.
Mentioned in the form, they can do many things first.
Overruled.
And then they can go to your Alex Jones Kangaroo Court Watch channel there, right?
Yes.
Okay. They can go ahead and click on the video that you gave yesterday outside this courthouse while Erica Lafferty was testifying, right?
I don't know that.
That's not you yesterday?
I didn't know that.
Objection, compound video,
Overruled.
testifying.
That's you yesterday, right?
Yes.
You gave that press conference, what, about 2 o'clock?
I mean, I don't understand the question.
You don't understand the question?
Yes, I gave a press conference.
Yeah, it was around 2 o'clock, right?
I believe so.
You know who was testifying at that time?
No.
Okay.
I was called here by you at 2, and then you said you didn't need me.
No, you were not, sir. So maybe you want to talk to your lawyer about that.
Objection to the colloquy and move to strike, Judge. I'm not in the case.
All right, so, Mr. Jones, I think you offered testimony and there was no question pending, so it's best not to do that, okay?
Judge, may we approach briefly sidebar? I'm
Your Honor, I'd like to move
ask
on.
for relief from the court based on a
I'll see you, counsel, on it.
We were warned about contempt, and he's trying to put me in the case with these snide comments, and I don't think you should tolerate it. Mr. Jones said something that was not true about when he was supposed to be here. Mr. I cannot do that.
I need to say something to correct it, because what he said was untrue. You need to say something?
No, I want you to admonish counsel. I am not in the case. I'm not going to be put in the case, or I'll get on the stand.
Let's not put Attorney Pattis in the case, but do you want me to say anything to the jury about the 2 o'clock? Or should we not?
I'd welcome you to say that what he just said was not accurate.
I don't know.
Because I didn't tell him to be here at 2 o'clock.
Here's the deal. At one point early in the day, he said, I made him available at 2. Early in the day, you alerted me. Now, I don't know when I got to him. I just don't know. I did know that I asked him, Chris, please, before you
What do
start.
you want me to tell the jury, just so that we can move on?
Let's just move on. I just don't want to be, I don't want the sniping directed at me.
Okay.
We can pull that back up. And then down here is Greg Reese. That's your contractor?
Yes.
Okay. So anybody come to this band.video page, they got you up top, the Alex Jones Show. They can see anything they want there, right? Of your show.
Yes.
American Journal. That's the gentleman who comes on before you. Those are your 3 live broadcasts each day, yes?
Yes, Chris.
Okay. You can back out of that.
I tend to run a pretty formal courtroom, Mr. Jones, which is why I call you Mr. Jones.
Thank you.
So, Attorney Mary, Attorney Pattis.
Attorney Matty.
You've been telling your audience, Mr. Jones, this week and last, that this is a kangaroo court, that Judge Bellis is a tyrant. It's part of a plot. Because you don't want your audience to know what's really happening here. Isn't that correct?
No.
Objection, motion, eliminate opening a door.
I don't think I'm opening any door with that.
All right, so I think you can answer that question, sir, but just remember the issues that are off limits.
Because your credibility, sir, is the most important thing with your audience, isn't it?
How do I answer a question, Your Honor, that I've been barred?
Most important thing to you, is that a question that
It's the
you
most
can?
important thing with your audience.
No,
right?
my most important,
No, okay, no. Your credibility is not your most important thing.
it's crushing the globalist.
Crushing globalists. And you tell your audience that they need to keep letting you crush those globalists for the sake of their own families, right?
Objection, Judge. Motion limiting door opening.
Maybe I'm misunderstanding, but I
I'm
don't think
going
that
to
there's...
excuse the jury at this point for 5 minutes so that we can work out this issue, okay? So just be patient with us as you've been all along.
Maybe the way maybe the way should be excused if we're going to do this.
He's a
He's
party.
fine. I think he's got a right to be here.
So, I'm not sure I understand. Attorney Pettis might be right, and I just may not be getting it. So why don't we explore it a little bit and just.
My objection was Judge, if you want to hurt that.
No. Okay.
You know, Attorney Maddie inquired of Mr. Jones whether his credibility was his most important attribute. He said it wasn't. Then Mr. Jones offered crushing the globalist was, which was non-responsive. However, Mr. Maddie adopted the non-responsive answer in his next question and asked about crushing the globalists. Mr. Jones would testify that he believes that this trial was part of a plot to silence him, funded by the names I'm prohibited to utter in the jury's presence, and we've had extended argument about that. So I'm simply alerting the court that, in my view, if we're going to have a consistent law of the case, and Attorney Maddie's going to adopt that comment in his questioning, that's opening a door that I will seek to walk through. And so that the purpose of the objection was to alert the court and counsel of that.
So we don't, Attorney Maddie, we don't want to inject politics into this. So what do you suggest?
Sir, nobody's injecting politics into this. What I'm trying to get at, the question I was just about to ask Mr. Jones, was the fact that he tells his audience that they need him to crush the globalists to support their families. I'm not getting into whatever he's talking about this plot is in this courtroom. What I'm getting into is the general...
You don't get to take half an answer and adopt the one part you like and ignore the part you don't. And I think there's a way to ask that without opening the door.
There's nothing about Mr. Jones's relationship with his audience that has anything to do with who's funding this lawsuit.
Judge, if he's going to question my client's motives for wanting to crush the globalists and suggest it's all about $1, that's putting what he's all about right in the center of this case. And you may recall one of the questions I asked Clint Watts. Do you know whether Mr. Jones, how to use this term, gins the anger of the public up, or is he responding to an anger that's already there? Watts didn't know. Mr. Jones, whatever you may think of him and his conduct in Sandy Hook, has beliefs about the globalists. To question those motives about him, I think, will entitle me as a matter of right to respond in my rehabilitation of him.
And bring up what topics, though?
Who are these globalists? You were just, you were told that you were publishing 512 and 513 as part of an effort to rile up your audience to make a buck. You've denied that. What are you really doing? Are you trying, who are these globalists? Why do you think this trial is part of an effort to sign, who is the tyrant? Why do you think the judge has behaved? And if Attorney Maddie is going to call his credibility into question on these, I think I have a right to inquire about his beliefs. And I think that the court's been pretty firm with me in the last 3-4 days about where I can and can't go. mean, the record is clear. I think I've tried to ask questions within the scope of the exhibits the plaintiffs offer, but they always offer something and then say, oh, you can't use it for the purposes of defense, we can only use it as
I understand,
a sword.
so if you're going to ask Mr. Jones about the globalist, Attorney Pattis wants to elicit testimony about who the globalists are, and that apparently would violate.
I don't know if it was violated. What I just asked Mr. Jones.
I think that I accept Attorney Pattis's representation that it would.
Okay, well,
Am I understanding what you're saying, Attorney Pattis?
Well, I mean, obviously I'd have to get your permission to inquire, but I believe that this is opening the door.
If you accept Attorney Pattis's view here, then pretty much any question I ask Mr. Jones about what he does, Attorney Pattis is going to say it opens the door. So I don't think me asking him whether or not he's making money from saying this opens the door to this, whatever his...
Here's the problem with that. That's not the question you asked, Mr. I mean, and the record is quite clear. Denied it, and then gratuitously offered that crushing the globalist was. Counsel had two options at that point. It could have moved to strike that answer as non-responsive and then gone on to the question that he just asked. You're just here to make a buck. But he didn't. He adopted the answer, opening the door. It's part of a pattern in this case to use the motions in limine here as a sword rather than a shield. And we're entitled to swordsmanship as well, and we will engage it.
Right. So I think that you can inquire about his monetizing his audience and making money, but I think that you have to steer clear of eliciting testimony that opens the door to his testifying as to who the globalists are.
Thank you, Remy.
Do you need a minute?
No, I'm ready.
Yes.
Okay. Doing my mental count to 9. All right, the record will reflect the entire panel has returned. Please be seated. We all thank you for your continued patience. Whenever you're ready to.
Thank you, Your Honor. Mr. Jones, since this trial started September 13th, it's day 7. How much money has Free Speech Systems made?
I haven't kept track of it.
You haven't been getting daily text messages with the sales numbers?
No.
Your testimonies in the last week, nobody sent you any text messages or other communications with the daily sales?
I don't believe so.
Okay. Would you mind checking your phone at the break?
Objection.
Don't have my phone with me.
Okay. Well, when you get a chance.
Objection.
I couldn't hear.
Objection, that's not proper.
It's an ongoing discovery obligation.
Well, if that is the case, Attorney Titus, I'm sure you'll deal with it at the break. So we can move on.
You normally get daily sales reports, right?
Sometimes I do.
Tim Fruget sent you those?
No.
Tim Fruget sent you those back in 2019 and 2020?
Yes, that's when he was an employee, yes.
Right. Now he is an affiliate
Yes.
with you, right? He helps run this website called freeworldoutlet.com,
Yes.
and you have a financial interest in that, don't you?
I think it buys products from us.
Excuse me?
Buys products from us and sells them.
It buys products from you. You make money that way, and then they sell products on that website, right?
Yes.
And that's Tim Fruget, your former business director, right?
Yes.
And you set him up financially to do that, yes?
I don't believe so, no.
You don't recall testifying in your deposition, sir, that you funded Free World Outlet initially to get him off the ground?
Can you refresh me with that testimony?
I'm asking you right now, if you recall that.
I don't remember. Free World Outlet's a very small site.
Did you tell the corporate rep about that, freeworldoutlet.com?
I don't remember.
Okay. Who was the corporate rep, by the way?
Brittany
Objection, which one? When? Timing.
The one who testified here.
Brittany Paz.
And so Tim Fruget, who now helps run freeworldoutlet.com, he used to give you daily sales reports, yes?
Sometimes, yes.
Who does it now?
I've not been getting those reports.
Okay, well, who does it when you do get them?
I can go in and I can pull up the reports myself, but I've not been doing that because we don't.
Mr. Jones, the question I asked you is who's doing it now when you do get them?
Well, I'm not allowed.
Does anybody send you?
Objection, he's trying to answer, Judge.
I'm not allowed under the judge's order to tell you about what happened to my company.
That's not true, Mr. Jones. What I'm asking you is who sends you daily sales reports?
Yeah, he's answered, asked and answered several
I
times.
didn't get the answer, so can you say the answer? Who would?
Okay, you're telling me to answer the question.
All right, so, well, I'm going to excuse the jury again. You're gonna get your exercise today for those of you who wear Fitbits. So just put your pads down and you'll follow along. I think he's following the rules here. I think he was probably gonna say one of the bankruptcy.
That's just the bankruptcy people are in control of it.
Who sends you the daily sales report?
Objection, objection, objection.
All right, so.
They've taken it
so-
all.
Objection.
Well, that was nice and
I'll
loud.
get there, Judge.
So,
That calls for the identity of a person.
no, so in fairness to Mr. Jones, he could have said whatever the lingo is for a bankruptcy, what were you gonna say?
Yes, until yesterday, the CRO, the bankruptcy's in full control of everything.
All right, so,
And they,
That's not responsive to my question.
Objection.
no,
because I can't say it's,
so the question, no, you did the right thing. You asked who sent him who gets the daily sales reports now, and if the answer was the bankruptcy person, then he knows he's not supposed to say that.
I said who sends you daily sales
And
reports?
he said no one does. When he gets them from the bankruptcy people.
I don't think he said no one does.
He
but-
said no
That is
one
correct.
3 times.
All right, so what do you propose? All right, so why don't we get the panel? I think it's a good thing we brought the coffee pot today.
the jury be informed that that was an appropriate break because there was some concern about compliance with the court order?
No. Alrighty, welcome back. Take your seats whenever you're comfortable. So I hope you don't think we're, just be seated, I hope you don't think we're being impolite. We have issues to discuss, and it's so much easier to have you all get up and go to your own than us trying to all set up somewhere else. So just bear with us.
Thank you. Mr. Jones, I'm going to shift gears a little bit. Do you agree with me that your reputation is very important to you?
Objection to the form, Judge.
Overruled.
No, I don't agree.
Do you agree that protecting your identity from lies and falsehoods about you is something that you care about?
I care about freedom.
That was my question. So my question was, do you agree that protecting your identity, your own identity, from people lying about you? I mean, that's just a human thing, isn't it? Nobody wants to be lied about, right?
No.
And particularly about the core things that make them who they are, right?
Yes.
And you have those things in your life. Your family, yes?
Yes.
Your work?
Yes.
Your relationships with your loved ones, right?
Yes.
The lessons you learned as a young person about how to be in the world, yes?
Yes.
All of these things that go into who you are as a person, right?
Yes.
And you would never want to be maligned or lied about those things that are core to you, correct?
Yes, but I have been plenty.
You have been, and that's been hurtful, isn't it?
The world isn't an easy place. When people become political figures, they get in their arena.
You know what, I think that was probably what you were just trying to do there, was to suggest.
Objection.
Sustained, and as I told the jury, and I know you're probably sick of hearing it from me, but this case is not about politics, okay? It's a hearing of damages. Why don't we move on?
Were you just trying to suggest that my clients, these families, deserved what they got because they had stepped into the arena? Is that what you were just trying to say?
Objection, argumentative.
No.
That's not me, okay. What I'm trying to get at, though, Mr. Jones, is that these things that are core to who you are, core to anybody, is they're lied about and defamed. Even just to a small group of people, that can be very hurtful, can't it?
Yes.
And although you've been critical of this court and the judicial system, you yourself have sought protection in the courts when people have lied about you, haven't you?
I mean, I have before.
Yeah, and in fact, during this very lawsuit, you yourself have brought a lawsuit against others who you claimed had defamed you, correct?
So you're talking about the Young Turks?
Yeah. You did that, right?
Yes.
Can we bring up Exhibit 434 for Mr. Jones,
Is
please?
this fuller ID?
It's ID, Your Honor.
134?
Motion in limine politics.
434.
Motion in limine politics.
Why don't I take a look at it first?
Sure.
So, Mr. Jones,
Mr. Jones was asked about this in his deposition, Your Honor.
Doesn't matter, does it?
All right, I'll tell you. 9 pages, I believe. There's an exhibit that is attached.
maybe ID in here too?
Can I give you, I can give you my copy, Judge, if you want to
No,
look at
that's,
it.
I don't want to take your copy, just give me a minute. We have to keep Ron on his toes. Thank you.
He's going to talk about why he sued the Young Turks, and he believes that they're part of another political conspiracy. I mean, the problem with this fellow is everything is part of a conspiracy.
The complaint, which is an admission, is offered to show his knowledge of damages, his understanding of this. The Young Turks are another media organization.
They're a media?
They're a media
Right.
organization. That's it.
They're competing people who he thinks got co-opted as part of a conspiracy against him.
But look, that to me isn't in politics, and beyond that, that's not relevant for the purpose for which
But you
this
don't
is
get
offered.
my position is, Judge, the plaintiffs don't get to choose the purpose without opening. They can't say, well, we get to hurt, but you can't help your own client. It doesn't work that way. In the same way that many of the exhibits they've offered contain the very figures whose names I'm prohibited from mentioning.
I'm using it, and so.
Well, I don't know
said,
that you're using it. The court needs to rule.
I'd ask you, if this opens the door to anything beyond the issues that I'm going to ask him.
I'm going to ask him. I'll ask him why he sued the Young Turks, and then they're going to have to live with that answer.
You don't know. It might not. I mean, I don't know.
If he
I'm
answers
asking because I don't
truthfully,
know.
if he answers truthfully, he will talk about them being part of having been co-opted by a political opponent. Yes.
Based on what?
It doesn't have. It can be. It's his understanding. Well, I mean, my contention, Judge, is that the plaintiffs do not get to open a door and then say you can't look inside the room. And so there are ways to do this without opening that door. But if they're going to open it, we're going to walk.
How do you do it without opening the doors?
You've sued. You know about damages. No. So if the contention is you've sued, you know how people can sue for defamation. You sued for another group, correct? He acknowledged he did. You're seeking damages. You have money damages for your reputation. Yes. That's because you believe that's an appropriate thing to do. Isn't that right? I think that's what they're trying to get.
It's nothing political
I don't
about that.
always agree with them, but I'm agreeing with them.
Can I order this piece of the record?
Look, I'm going to ask the questions about it, and we can argue about what doors.
Well, I'm
It'd be much
objecting.
better if you did it along those lines so it doesn't open the door.
I don't want to talk about politics with this guy at all. I'm going to ask him
He
about this
doesn't-
lawsuit and his claim that he was previously. Okay, well,
Judge, I think they do so at their peril.
fine.
Record based on what I entered at Sidebar.
So that is on the record, so we have the record and it will be admitted over objection.
So before we pull it up, let's just give the jury a look back. So you brought this lawsuit against an individual named Brianna Wu, correct?
Yes,
An individual named Andrew Kimmel, yes?
yes,
And a entity called the Young Turks LLC, correct?
yes,
And you brought that lawsuit in September of 2019, correct?
yes,
Okay. So about a year and a half after this lawsuit had been filed.
yes.
And do you know who Brianna Wu is?
It was people online, so-called journalists, saying,
I just asked you about Brianna Wu, so I want to
I
ask
don't remember who she is now.
Okay, you don't remember who she is, thank you. Do you remember who Andrew Kimmel is?
Not really.
Okay. But you sued them.
I mean, yes,
Okay. And the Young Turks LLC, am I correct that that's a media organization?
yes,
Okay. And you brought this lawsuit because you claimed that these people had spread a lie about you, right?
Objection, motion to eliminate.
You wanted
it wasn't money.
Well, we'll get into that. But what you wanted was you sued them because you believed they had spread a lie about you, correct?
Yes, it was directly connected to this case.
Correct. So let's get into that. So what happened was, back in 2019, you were required to produce some documents to the plaintiffs in this case, correct?
And I did.
Okay. And among the documents that you gave to your lawyers and that your lawyers produced to us were some emails, correct?
Yes, I
And
think 207,000.
so, sir, really? You just have to answer my
Right,
question,
so-
yes or no? All right.
Objection to the
So,
comments.
excuse me, so if anyone, either of you need any help with any witness not answering the questions that you're asked, ask me to do it, that's my job, I like to do my job, I'm not bad at my job. I know you know what I'm gonna say, Mr. Jones, go here.
Just yes or no.
Yeah, or I don't.
Okay.
Okay, just answer, sir.
And,
No,
oh, I'm sorry.
still speaking.
Thank you, I'm sorry.
Mr. Jones, just look at me. Just yes, no, or I don't know.
I see. Yes.
Thank you.
Your lawyers were images of child pornography, correct?
Yes,
And the FBI was alerted about this, right?
yes,
And the FBI concluded that while those emails were in your organization's possession, they had been sent to your organization from outside, correct?
yes,
And that there wasn't any evidence that you or anybody in your organization had opened them, correct?
yes,
In other words, that although they had been sent to us, that had been done inadvertently, correct?
yes,
And when you were advised of this, you were upset, yes?
yes,
And so you went on the air, correct?
yes,
And you blamed my office for having planted it, correct?
no,
Mr. Jones, do you want to see the video, sir?
go ahead and roll it.
Would you like me to?
I mean, if you want to.
You offered $1 million to have my head on a pike.
No, objection, that mischaracterizes it. This, may we approach?
I don't think we need to. That's
Yeah,
a yes
I
or no.
do.
So, come on.
He was never charged
The
with a
judge has
crime.
seen the video.
You've seen the video, and he said he talked about his suspicions about Mr. Manny, but he never said, he said he'd offer $1 million for the person who did it. He had suspicions about him. To suggest as an officer of the court otherwise, excuse me, to suggest otherwise as an officer of the court, I'm asking for a curative instruction and admonishment of counsel.
Watch the video.
I was sitting there, I don't
Can
need
you
to.
ask, so I'm not gonna give a curative instruction, I'm not gonna admonish. Can you ask me a different way?
Well, he hasn't answered it.
Right, so
So you can say
it's
no, I
objected
guess.
to, so can you ask it in a different way?
No, he can say no if he wants, and I can impeach him.
Can you ask it in a different way
I
then?
don't want to ask it in a different way.
So you're not sustaining the objection and then
Thank
you
you.
try to ask it. And Attorney, we're due for a break anytime between now and the next 10 minutes. I'm gonna leave it up to
Great.
you as to when is a good point.
Thank you. Yep. So, Mr. Jones, when you found out about this, you went on your show, right?
Yes,
And you held my picture up to your audience, yes?
no, I believe you conflated your picture being on the pile of stuff, me saying it was a reward to find out who did it. So how is there a reward if we don't?
So, Mr. Jones, the question was, you held my picture up, and I'm not sure I got your answer. Was it yes, no, or I don't know?
Or you don't recall.
I don't recall.
what he said.
I don't recall.
Do you recall pounding on my picture? Do you recall
I
that?
pounded my desk all the time. It was a pile of papers. I remember that.
Okay, all right. And the reason I'm doing this is because when you went on the air and did all that, people found out that there was this issue about your company having sent child pornography to my office, correct? That's how people found out about it.
Well, you're not going to be clear that someone sent it to me.
No. I think we've established that.
No, but you're getting it set up for clips, though. I know what you're doing.
Mr. Jones, really, I think it's established, and nobody contests that you had nothing to do with that child pornography. Okay, let's make that clear.
Yeah, you guys found it.
Correct. We found it because it was sent to us, right?
It was embedded, and then you guys found it. Really good job.
So, Mr. Jones.
I know I'm not supposed to start.
No, okay. No commentary.
Gosh, yeah.
Answer the question.
It became public that there was this whole issue that child pornography had been sent from your company to my law office, correct?
Objection, Judge, that calls for speculation that maybe
Overruled.
one avenue.
I don't remember.
All right. But in any event, once it became public, you claimed that Brianna Wu and Andrew Pimmel and the Young Turks had lied about you having sent it, correct?
They said more than that, if I remember.
Right. And you alleged that in your complaint, right?
Yes.
And that was deeply harmful to you, that they had lied about the fact that you had sent child pornography, right?
People still say it all the time everywhere.
It's a terrible thing to be accused of, correct?
Yeah, but they quit saying it, so I dropped the suit.
And they were spreading to all over the internet this lie about you, that you had sent child pornography, correct?
Purposely, yeah, that was the issue.
And that's why you brought this lawsuit, yes?
Yeah.
Okay. Your Honor, this would be a fine time for a break.
All right, so we will take our morning recess now, 15 minutes. I know you're probably saying to yourself, why do we need another recess? We just got up and down, but our staff has been here, and we've been working the whole entire time, and so I'm required to give them a break. So you'll continue to obey the rules of your I have to watch off so much that I can't even find the clock. 12, let's say 12:10, okay? So we'll take a recess.
Yes.
And reaching a wide audience, yes?
Yes.
And the more people who come into contact with this, as you called it, one of the worst smears that can be spread about anyone, the more people that came in contact with that, the more damage was being done to you, correct?
I mean, I think that's fair to say.
And because the more people who see this, the more people who might believe it, right?
Well, I don't know they're going to believe it, but
That's the concern, right?
yes.
Because if people believe, especially a large number of people who encounter this lie on the internet, that you possess child pornography, that would be a horrible, horrible stain on your reputation as an individual, correct?
I think it's 20 years in prison, too.
Correct. They accused you of a felony, didn't they?
Yes.
And not only just any felony. Child pornography, right?
And distributing it.
And distributing it. And it's the type of allegation that would provoke a lot of anger in people who if they were to believe that about you, right?
Yes.
And might provoke people to even want to confront you about it, right?
Objection calls for speculation what might occur.
Sustained.
I think you testified earlier that you have come across people who have accused you of this, right?
It's still ongoing.
Right. And if that happens, obviously there are certain measures you need to take to try and protect yourself from people who may need to do you harm as a result of this, right?
And when they stop saying it, we drop the suit. We just want them to stop saying it.
But I'm just saying, when people believe something horrible like this, that you're a child pornographer, that could lead to people who believe it to hate you, right?
Objection calls for speculation.
Overruled.
I mean, I think that's fair to say.
And if they really believed it and they really hated you, you might have a few people come after you, right?
Objection speculative.
Overruled.
Well, like the police.
That's one, right? But what about people who are just out there and unhinged, thinking, Alex Jones, child pornographer. Next time I see him, boy.
A name. I didn't name most of these people's names.
Yeah, I'm not asking you about that, right? I know you might kind of see where I'm going here.
Objection.
I do.
Move to strike.
Let's move on to the next question.
And as a result of that concern, you yourself have taken measures to protect you and your family, correct?
We have to have more security because of the Sandy Hook thing, actually, than that.
But you got security guards in the courtroom right now, don't you?
Yeah.
These two gentlemen over here in the black jackets, that's part of your security team?
Yes.
They follow you everywhere you go, right?
Yes, not due to the fake child porn, but due to this.
You've had a security team for a long time, haven't you?
That's but the main. I mean, you're asking.
I'm just asking you.
Objection.
Have you had a security team for a long time?
Doors.
It's a yes or no, whether he's had a security team for.
Why? Objection.
4 years since the Sandy Hook suits.
And this gentleman here on the right, that's Tim Enwell, is that right?
Yes.
Okay, he's your head of security?
Yes.
And they walk around with earpieces, right? So they can communicate with one another?
I don't know they have those.
You flew up here on a private jet, is that right?
A charter plane.
Charter plane, okay. And so one of the reasons you do that is because you travel commercial, you know who you're gonna run into, right?
Since this case, yes.
Okay.
Since the Texas case, it's
Just really
Objection, Judge, again.
So let's just get the
Is it your
next question.
testimony,
Objection that we
that you've never
Right,
chartered?
just 1 second. Sidebar, please. So, I'm gonna get this. I don't want to be interrupting. So what do you suggest? You're talking. I can't hear you. Can we stop? Can we stop?
I objected to his instructing counsel, which is the role of the court. You can set that
So if you haven't, you just, I don't want to interject myself more than that. But if you're not, just ask me. And I'm happy to do it.
Yep.
So just as a gentle reminder, Mr. Jones,
yes, ma'am.
just try to listen to the questions I was asked. If there's an objection, we'll stop, and then, yes or no, or I don't know right on local, okay?
Is it your sworn testimony that you've never chartered a private jet before this lawsuit, sir?
Yes,
Never, before 2018, had you chartered a private jet. You sure you want to say that?
yes,
We won't see any expenses prior to 2018 for any private chartered air travel, correct?
you said a jet. I mean, I think we rented Cessnas for aerial news shows at the border. One time, me and my wife and my children were in Canada. We rented a seaplane that flew us for a couple hours up to a place to eat. But other than that, I've never known. Not till now. Not till this.
Okay, so your testimony is that prior to this lawsuit, you actually did fly on chartered planes, correct?
No, you said a jet.
I'm sorry. If I was confusing you, but with the word jet.
Would a hot air balloon count? I have also rented those a few times in my life.
Okay, let's,
No, that's not what I was referring to. But
I have rented.
all right, so,
I,
wait
go ahead.
just wait for a question, there's no question.
Just see if you can answer this yes or no, sir. Prior to this lawsuit, you had paid for chartered private air travel, correct?
Yes, not jets.
And in addition to the security team that you have and your private air travel arrangements, I take it that you have security systems at your homes, correct?
Sure.
So with this lawsuit, why don't we bring up paragraph 7 on page 3.
Has it been admitted, Judge?
I think I did offer it.
I don't know the doors are open.
I think you moved it to Sidebar.
Which number was it?
424.
424?
34.
It was objected to?
434.
Yes, 434 was made a full exhibit about 45 minutes ago.
So let's pull up paragraph 7 with my critique, please. Okay. And this is a complaint that one of your lawyers, Robert Barnes, drafted on your behalf, correct?
Yes.
It was filed in a lawsuit to commence this lawsuit against these people.
Yes.
And one of the claims you made was that on June 17th, 2019, at 9:40 with that group, yes? St. Uyghur is a person associated with
Yes.
Uyghurs. Published on its Twitter account, quote, Alex Jones sent child porn to Sandy Hook parents. See Exhibit 1. The Young Turks Twitter account. And that's at the same headline made the Young Turks video page, where it still stands today. And so there was a tweet, right? And there was a headline associated on their video page, according to this paragraph, correct?
I believe so.
All right. And if you go further down, you say here that they hold themselves out as, quote, serious journalists with millions of followers across multiple social media platforms and the biggest media network on YouTube that is completely monetized by YouTube, et cetera, correct?
Yes.
And the point of that is to show that these people who you claim lied about you had a significant platform that could result in significant harm to you, yes?
Yes, and we weren't allowed to respond back because we weren't on that platform.
Okay. So, I'm just right there.
Sustained.
So, you then go down further, and let's go to paragraph 12. One of the things in a claim for defamation per se, the words are so obviously hurtful that they require no proof that they caused injury in order for them to be actionable. Accusing a professional of deliberately sending child pornography to opposing attorneys is a serious felony, raises no questions as to its negative effect on your professional reputation, right?
Yes, they said my name.
Yeah, right. The idea is that this type of allegation is so hurtful that just the fact that it was made shows that there was damage done, right?
I'm not a lawyer, but under the law, if you say the name, too, you have to say the person's name.
Yeah, you're not a lawyer, are you?
But
Right, so you're not, right?
No.
Okay. And when you did this, you attached as proof. Oh, let's go to page 6. Yeah, page 6. And at the end of it, after you made these allegations, you said, wherefore, plaintiff respectfully prays for judgment against the defendants in a sum to be determined by a jury, right? Did I read that correctly?
Yes.
You included an exhibit. And let's go to exhibit 8. I'm sorry, page 8. This is exhibit 1. Oh, thank you. Appreciate it.
So I'm sorry to interrupt, counsel, but you're referring to an exhibit that's part of this exhibit.
Yes, thank you. There was an exhibit 1 attached to the complaint. Thank you.
That was come around to see the board here?
Yeah.
Sure.
Yeah, I'm not going to use it just yet.
Let him just get situated so he can take this.
And as you see, here, this is the tweet that was so concerning to you, right? And there's a video associated with it, obviously not here on the printout.
No, it was what they said in the video where they said I was going to jail and I did it on purpose and a bunch of other incredible stuff.
I'm going to strike that, Your Honor.
Okay.
What you included in support of your lawsuit was this, yes?
Yes, an image of the video so you can see the video.
And the headline was Alex Jones sent child porn to Sandy Hook parents, correct?
Yes.
Now, as a technical matter, your agents did send child pornography. And down here, if you look at the bottom, how many retweets did this tweet have? You might have it in front of you, sir, if that's easier.
20.
20. And how many likes?
37.
Okay. And then over here, this is 132. Those are comments, yes?
I don't know.
You don't remember that? Okay.
The issue is the video, not
I didn't ask you any questions, sir. All right, you can take that down. So there were 20 retweets and 37 likes, right?
Yes.
Okay, so we're going to put TYT, that's Young Turks, right?
Yes.
So there were 20 retweets.
Do you need Mr. Jones to see that board? Because I'm not sure he can. Can you see that board?
I can see it.
Oh, never mind.
A little
You can
bit.
see it?
A little bit.
And 37 likes, right?
Yes.
Now, you said you've been watching. Clint Watts testified here earlier this week, correct?
Yes.
And did you hear his testimony that at a minimum, your lies about Sandy Hook reached 550 million just on social media alone? Did you recall that testimony?
Yes.
That's a yes or no?
Yes, I recall it.
You recall it.
Preposterous.
Move to strike, Your Honor.
And so, sir, just remember, no comments, just
Oh,
answer
yes,
the
thank you.
question. Thank you.
I'm done with this. Huh? I got it, thank you. Now, Mr. Jones, the lie you spread for years and years was that the families behind me were actors, correct?
I can't
That's
answer.
a yes or no.
No objection.
It's too complex. Sorry.
Motion eliminated.
Can I have a sidebar on that? The lies that you spread
He doesn't think they were lies. I mean, the court has made that finding. And so this is the heart of that Fifth Amendment issue I alerted the court to. If he agrees with the characterization that it's a lie, he's testifying falsely. If he testifies truthfully, he's in contempt of a prior ruling of the court.
So I'll do something a little different.
Okay, that's a good point, though.
I mean, look, he could take the fifth. So
If we're going to get to that, I'd rather do it outside the jury's presence because my claim.
I'll try something.
Okay.
Chris.
So just wait for the next question, Mr. Jones.
Man, I'm sorry.
Yes.
All right.
We'll let
Mr.
them-
Jones, for years and years and years, you called these. That's not correct.
No.
Do you remember in your deposition, sir? I asked you about Robbie Parker, right?
Yes.
And you always called Robbie Parker an actor many times, didn't you?
No, I said it looked like he was acting.
You said it looked like he was acting?
The internet is a huge thing.
Mr. Jones, is your
Objection, my
testimony...
client wasn't permitted to finish his answer.
These are not yes or-
No, Mr. Jones, I'm sorry, because now I've lost the question. So can you ask the question?
You know what? Let's do it this way. Mr. Jones, would you agree with me that if somebody were to lie about a group of people and call them actors and having faked their children's death, that would be a horrible thing to say about something?
I did not call
Is
them
he yes or
liars.
no?
As to the vouching in proper form, it's a contrarian voucher. Nobody cares whether he agrees with Mr. Manager.
All right, sustained.
Mr. Jones, if someone were to falsely claim that a group of families who had lost loved ones were actors and had faked the deaths of their loved ones, that would be a horrible thing to say, correct?
In the context, it could be, yes.
Could be. To millions and millions and millions of people, one would expect those families who have been falsely accused to be damaged, correct?
Objection, speculation, Judge.
Overruled.
Yes or no, sir?
I cannot answer this question truthfully without violating the court's order.
Well, why don't we have an invocation then?
What's an invocation?
Oh, no, wait, Judge. This
All
is
right.
improper. I'm going to object.
So why don't I excuse the jury for a minute? This shouldn't be too long. Okay, so the question again?
Well, Judge, before we move on, we had an agreement that if there was going to be any Fifth Amendment claims here, it would be done outside the presence of the jury, and then we're asking for an invocation.
When you say we had an agreement, you and Attorney.
Well, no, Attorney Pattis requested that. I wasn't prepared for him to invoke.
Effort to evoke the Fifth Amendment or to elicit a Fifth Amendment response to be done outside the presence of the jury.
That's fine, but that's not what I was doing. I think the question will show that there's no valid assertion there.
All right, well, why don't, can you give me the question again? Or do you want me to play it back?
Yes.
Why don't we play it back?
Okay, take your time, Madam Monitor.
deaths of their loved ones. That would be a horrible thing to say, correct?
In the context, it could be, yes.
Okay. And if somebody were to spread that claim to millions and millions and millions of people, one would expect those families who have been falsely accused to be damaged, correct? Objection, staff ratio. Yes, no, sir.
I cannot answer this question truthfully without following what's word.
Well, why don't we have an petition then?
What's in the case?
Or anybody else. Okay.
So we alerted the court earlier on that there may be an unusual Fifth Amendment issue in this case arising from the law of the case. Mr. Jones has suffered a disciplinary default in this case, resulting in his inability to contest liability. The court has established during the law of the case that...
Can we just back up for a second? So the question wasn't about Mr. Jones specifically, although maybe it was getting there. The question was, if someone spread that claim to millions and millions of people, one would expect people to be damaged. There's no...
No, you're missing a predicate in there, falsely. If they falsely spread this information.
Right, but this is not talking about Mr. Jones or free speech systems. This was a hypothetical.
He's not an expert, and he can't be questioned as an expert. He's here as a fact witness. And the fact that this is an attempt to sidestep the ruling, and once again have the motion in limine be used as a sword rather than a shield. Is that Mr. Jones, the law of the case is that the court has concluded these statements were false, not because they were litigated, but because of failure to comply with discovery. We can't talk about that. The plaintiffs have earned the right to call him a liar in open court. Whether we agree or not, that's the law of the case. What they've not done is earn the right to put him in a position where he either disagrees with their characterization of him, thus running afoul of a prior ruling of the court, or agrees with them, thus committing perjury. We would go further and say that if we get to a point where an invocation is necessary, they're not entitled to an adverse inference because that is giving undue weight to
So, Attorney Pattis, what would be wrong if his answer, his true answer, how would it violate the order, is if he says he denies the extent of the damage?
Well, I don't know that that's responsive to the question, candidly.
Yeah, so, Your Honor, I think what's happening here is we had a sidebar to avoid a proper assertion. I said I'll do it a different way. And so I came back here, and instead of telling Mr. Jones that he had lied, I said if one did, that would cause damage.
Well, who cares?
Well, I think and I don't want to tell you how to ask it, but
This is,
no, let me just
I'm sorry.
get it out. We're not putting Mr. Jones in a pickle, but where the jury understands that the issue has been decided, which they've been told many, many times now. So can you think of a way to do it along those lines? So here, the court has already determined that liability is not an issue. The jury is just determining damages. And so what's the question for Mr. Jones?
No, there is no, first of all, he's a defendant. This isn't impeachment on credibility grounds.
What the question is.
The question is, rather than ask him directly, where he now thinks, a truthful answer would somehow incriminate himself, I've asked him whether or not one would expect that if one were to do these things, it would cause harm. Now, Attorney Pattis is still free to argue at any point that the harm caused here wasn't what the plaintiffs alleged. That's what he's apparently claiming. But Mr. Jones's response to that question, if the answer is yes, one would expect that type of harm, that doesn't violate the court's orders, and it's not false. If the answer is no, one right? So either one, he can testify truthfully without violating the court's order and putting himself in contempt.
Or I don't know.
Or I don't know.
All right, so
The
how
problem
is,
with that, Judge, is it's argumentative in tone. He's not an expert, and so what one does isn't what we're
But
here to
that's
show.
a-
We're here to show what he did.
right, but
And the
that's a
purpose is
different,
being
no,
offered to
Attorney
get into the
Pattis,
same
Attorney
line.
Pattis, Attorney Pattis, how many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. So, your objection was that it was a motion in limine issue, I thought, that it would require him to lie. I now hear that it's a different objection, that it's speculative, he's not an expert.
I'm waiting to finish, so I don't want to follow your order. I have been in offshore court for a long time. As you know, I insist on making my record, so thank you. And I'm sorry that I stepped on your question. I thought I wasn't done. What I was trying to say was the following. I objected because he's trying to get an evocation in the jury's presence, which is entirely improper, without permission of the court. I objected further because he was asking Mr. Jones a question that places him on the horns of the dilemma. In the course of all of his proffer outside the jury's presence, he's now switched it to one would expect. Mind, but his conduct is.
I can't disagree with that, so I will sustain the objection. And where does that leave us with respect to possible future invocation?
If there's going to be an invocation, I've requested it be, if the prelude to it be outside the jury's presence so that I can argue about whether the plaintiffs are entitled.
All right, so how does that work procedurally? So there's a question, you're gonna invoke on his behalf?
I can't do that, I don't think. It's certainly in the jury's presence. I'll I'll simply say
in a
motion
civil
about
case.
evocation.
I think
Motion
in a-
about evocation.
Okay, does that work, Attorney Matty?
Sure, that's fine.
Okay, so if that happens, Mr. Jones, if that happens, just put the brakes on, right? So that we can do it. Okay, let's bring the jury out. So, can I just see counsel in the meantime? So I can count on one hand how many times I've argued on the encounters on my entire career.
You're right. You're right.
That's a positive note.
Look, Judge, here's the deal. I'm an advocate. I get lost in the moment. You've admonished me, and I'm working on it.
You're standing up for it, right?
I'm a member of Advocates Anonymous, Judge. If I warm too much to my client's cause, that's why courts are here to assure fair trials.
We're good. Okay, welcome back. As promised, we were pretty quick, so thank you for your patience. Please be seated. The record will reflect that our entire panel has returned. Let's give them a minute to settle in. And whenever you're ready, Attorney Matty, please.
Thank you, Your Honor. You remember in your deposition, sir, you referred to, asked you some questions about Robbie Parker, correct?
Yes.
And I showed you a video where you were describing not just one parent, but a bunch of parents coming up and doing the fake crying in the lab. Do you remember that video?
No, I don't.
Why don't we show 19...
Which exhibit is this? I'm sorry. 19?
19i.
A as in
19i.
I.
It is a full exhibit.
Thank you.
CNN admits they did fake scud attacks on themselves back in 1991, 1990. Would they stage this? I don't know. Do penguins live in Antarctica? Wolfgang W. Halbig's our guest, former state police officer, then worked for the Customs Department, and then over the last decades created one of the biggest, most successful school safety training groups, and he just has gone and investigated, and it's his phone needs a $3 bill, and they've been, but man, Wolfgang, you dropped a bombshell of yours. Of 100 kids, and then nobody can find them, and then you've got parents laughing, going, ha, 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 and they walk over to the camera and go, and, I mean, not just one, but a bunch of parents doing this, and then photos of kids that are still alive, they said died. I mean, they think we're so dumb that it's really hidden in plain view.
So, Mr. Jones, does that refresh your recollection about referring to not just one parent, but a bunch of parents doing the fake crime in the last?
Yes, it does.
Okay. And when you were deposed, you acknowledged, did you not, that you had referred to the parents who had brought this case as actors? Didn't you acknowledge that then?
I mean, the only person's name I ever said was Robbie Parker, but I guess that clip's from like 7 years ago or wherever it is. They're all long time ago.
So, Mr. Jones, just let's get back to answer the
Oh,
question.
sorry.
So the question was, do you remember in your deposition where you acknowledged that the families who had brought this case you had called actors? Do you remember that testimony, sir?
I think we've had like 4 depositions. Which one was it?
You remember you were in my office?
Yes.
We were in a conference room?
Yes.
Okay, I was sitting just about as far as I am from the court reporter from you.
I'm trying to remember we've had quite a few.
You and I have only had 2 in person, correct?
Yes. I mean,
Okay. All right, well, Mr. Jones, I'm talking about the ones when you were in person sitting right next to me.
okay, that's why I'm trying to refresh my memory.
So, am I correct that during that deposition, you acknowledged under oath that you had referred to these families as actors?
I don't remember the testimony, but I never even seen their faces most of them until they sued me. I don't know. So I can't answer your question. I don't have the answer to that.
You just don't remember that testimony is your answer, right?
I believe it's the same testimony I gave her today.
Okay. Okay, well, why don't we, may I approach her?
You may.
Okay. Mr. Jones, I'm going to ask you to look at page 252. You see this question where I say, I'm asking.
Which exhibit, sir?
This is Mr. Jones'
Oh,
deposition.
there are 4 of them. Which one is that?
April 5th, 2022.
Page 252.
Thank you.
I'm asking if you'd agree with that. You've given me 2 options here. Somebody who is really who they say they are, but they're going along with the official script. Those are the options you gave me. Answer, yes, that's what you said, right?
Yes.
The first option, Robbie Parker is an actor creating a role. In that circumstance, Robbie Parker is just a fictitious character, correct? What'd you say?
Yes. That's role playing, yes.
You said yes, right?
Yeah.
In that context, the actor playing Robbie Parker would be going out in front of the whole world to give a statement, knowing that he's just playing a fictitious part, correct? What'd you say?
Yes.
You remember in your deposition you acknowledged that for this hoax to work, it couldn't just be Robbie Parker who was an actor. They all had to be in on it, correct?
You've refreshed my memory. I believe I was answering your hypothetical questions.
Okay. Listen to the question I just asked
All right.
you. You acknowledged in your deposition be pulled off it wouldn't just be Robbie Parker, it would have to be all the families who were actors, correct?
We're recovering the controversy of was it staged or not.
Move to strike, Your Honor.
Sustained.
Can you answer that question, sir?
Can you refresh me with the transcript?
Sure.
The last one was very helpful.
In fact, you know what, let's just pull it up for everybody.
So this is exhibit.
One moment, Your Honor. We have this clip, right? Now we're going to play a portion of Mr. Jones's deposition. It's an admission.
What was the exhibit number on this, Judge?
It's not an exhibit, it's an admission. But we'll get to the number for the deposition. Thank you for your patience, Your Honor.
No problem.
While we're doing that, Mr. Jones, what's a Potemkin village?
A Potemkin village, I believe, goes back to examples like the villages, the PR stunts. And I think there was some, I forget the exact historic nature of it. I may be wrong about that. It's something to do with Russian history and government staging events.
Right. And this Potemkin village would be filled with people to play parts as if they were villagers, correct?
Yes.
Actors in a hoax that the government was staging.
It's like the Truman Show.
And the Truman Show, that's a movie, yes?
Yes.
Where this fake village is plopped down and everybody who populates it is in on the hoax, yes?
I think that's what the movie's about.
And that's what a Potemkin village is, to your understanding?
It's got a lot of definitions, but I think that's a fair one.
Is that about right? Is that how you were using it when you were deposed?
You got to refresh my memory.
That's what we're trying to do here. All right, we'll play that.
Your claim, in response to my question, that there is a fictitious that by going in front of the camera to millions and millions of people, there would be somebody who would know, hey, I know that guy. That's not Robbie Parker, right? Objection. Just answer that question. Do you think that, is that a reasonable expectation?
No.
Okay. Objection. And if somebody were to recognize,
It's a Potemkin village.
if somebody were to recognize the person playing Robbie Parker isn't in fact Robbie Parker, that would blow the whole hoax, right? Objection.
Objection. You know what a Potemkin village is?
Answer my question.
No, this is a Potemkin village.
Okay. By Potemkin Village, you mean everybody who was in the immediate community would have been in on it.
Well, they set that up
Right?
during World War II.
That's what, no. That's what you mean, that everybody in the community is in on it.
Not everybody, but in a close-knit area.
Which would mean, it's certainly all the parents of children who were killed would have to be part of that conspiracy, right?
Or maybe it didn't even happen.
That'd be a good time for lunch break, Your Honor.
I think so. 372?
Yes, Your Honor.
Okay, so we will take our lunch break. We'll be back right for 2 p.m. It is as imperative as always that you continue to obey the rules of juror conduct. Ron will take your notepads. If you go out, I'm not sure what the weather's like, it's hard to tell, but if you do venture out, just make sure that as you come back in, you avoid any of the witnesses or parties or lawyers associated with the case and any media that you might see. So I hope everyone has a nice lunch. We'll take a recess.
gotta go now.